You give your appearance, sir. Before commencing the matter, I request all the learned advocates on record who are appearing on various matters to kindly check the cause title, name, I'm sorry, the number of the WPA, the names of the parties, and the names of the learned advocates. If
But
there is-
I stand in all cases because I am appearing for the commission.
Naturally. So all the learned advocate on record for the petitioners are requested to go through the earlier orders. Otherwise, it may again each and every occasion you may
There will be
come and
correction.
take action.
3 of 2024. My lord, I am for the petitioners in WPA 29253.
Because I have also observed that for last 2-3 days.
My lord, I am representing the petitioners. WPA 29253 of 2024. 3 of 2024. My lord, this is Rumpa Shamanto and others. Shamanto. And others, there are 22 petitioners, my lord. Yes, come. My lord.
Mr. Chatterjee, first introduce your petitioners.
Yes.
Who are they?
My lord,
That
my
is because
22 petitioners, my lord, they have found their names are featured in the final panel, which was prepared for the purpose of conducting the counseling, which was fixed, scheduled to be fixed on the date which was notified to me on 5th of October 2024 and
for personality test,
for counseling.
for counsel.
Would you kindly come to
So you have been succeeding in the
every
counseling test.
counseling?
Now tell me one thing. You are an examinee of 2011 examination, or you are an exam?
I
No,
have-
please
yes,
tell me that.
yes. I have not been qualified to participate in the written examination in 2010. Subsequently,
2011.
2011, when it was conducted.
Yes.
Subsequently, when the re-evaluation decision was taken by the commission, and the OMRs belongs to all candidates.
Sir, we know. In the meantime, we have come across. I want to know
I
whether
was
you are an
given the chance to
examinee
sit
of
for the examination
second,
in 2024.
24. Just a minute.
And there I am different from Mr. Bhattacharya's kinds.
Examinee in 2024 written examination. Yes, Mr. Chatterjee.
Already, in order to make it lucid, what I have done, I tried to gather the all informations related to petitioners in respect of the 11 petitions. And what I have found, these facts would be very crucial to adjudicate according to the subject to correction method. That all the petitioners in all the petitions are equal in one respect. That is, my lord, each one of them, in all the petitions, in 11 petitions, they have qualified in the preliminary examination, which was held in the year 2000. This is an admitted fact subject to correction. Number two, my lord.
No, that is not admitted. The writ petitioners do not admit you that you are successful.
I have gone through. They have all the petitioners. I say, my lord, in 11 petitions, there are several petitioners.
They do not recognize you.
They may not. My lord,
So it is not an admitted question. It is a disputed question, which is to be decided.
This is admitted because these are material on record. They themselves have stated.
Only Mr. Chatterjee, so far my understanding goes, the only admitted facts is that you all appeared in the preliminary screening test.
I joined.
This much I have admitted.
Yes. So everybody.
This much has been admitted. Now, for some reason or other, your clients do not, for some reason or other, your clients do not get success in the preliminary round. So they fail to appear in the 2011 examination. Now, on account of detection of so-called error or something like that, you have been permitted to appear in the written examination of 2024. Now we have come across through the said written test, you have passed the Viva OC. This much I can understand.
So everybody is on same pedestal. So far the preliminary test is concerned, everybody was qualified. Everybody. Second, my lord, for the purpose of the preliminary test, there were 3 sessions conducted. 3 sessions. Each session had its own participations, which has been revealed by the commission in their comprehensive assessment. And some of them were called for the written test in 2010.
11.
Some of them.
29/5/2011.
Some of them were called. Thereafter, my lord, there is an awardment by the commission in the affidavit. There was the entire process was withheld. Now, suddenly, next fact, which is very important, would be crucial, that commission detected there were certain discrepancy on their part, error, which is exclusive technical in nature. An error is, my lord, that commission which was duty bound to evaluate all the OMR sheets of the preliminary test, screening test, where all of us we have participated with the appropriate answer key. Session 1, session 2, and session 3. Each session had its own answer key. Now, commission found that all the candidates' OMRs were evaluated by the answer key, which was exclusively made for session 2. That is a technical error by nature, which can be recovered, detected, and rectified. Number 4, nobody will dispute that all these repetitions, including my repetition also, has been filed after the commission had issued notification for the written test. Written test was conducted. After conduct of the written test, panel was published. When the commission decided to start the counseling, when commission was in charge of giving the job, after 15 long years, when there was no recruitment at all, commission decided to go ahead with this. Whether commission was permitted to do so or not, Lordship, I will demonstrate it by the latest decision of the Honorable Supreme Court delivered in 2025. I will come to that. But before coming to that, Lordship, I want to make my submission very clear that none of the petitioners who have come before this court to prevent the commission to continue with the recruitment process has come with the clean hand. I say none of them, if they were so vigilant, if they were so much anxious about this recruitment process, they should have filed the writ petitions immediately the orders of written examination was issued. Lordship, kindly note few dates. I will hand over.
Give me a second, Mr. Chief. Yes, Mr. Chatterjee.
Kindly consider this list which I have prepared.
Kullan Babu.
These are from the
Note করে দিন,
records
note করে দিন,
subject
note
to
করে দিন।
corrections which were available on Shartok. I got some of the petitions from Shartok.
2925.
24588 of 2024 by
Let the paper be placed first. They are making some noting. WPA 29253. WPA 29253 of 2024 for the petitioners. Yes, Mr. Chatterjee.
Kindly come to the WPA 24588 of 2024, the petition which was filed on 24 September 2024, which was affirmed on 24 September 2024. Next petition, Abdul Latif and others, which was affirmed on 14/1/2025. Hafizul Haq. This was affirmed on 24/8/2024. Muhammad Habib Mundal and others, they were qualified. This is, I think, the petition by Mr. Bhattacharya has represented. Qualified in screening test in 2010 and written test in 2011. Well, then Joyanto Shodhar and others. I did not find the date of affirmation, but filing date was 14/10/2024. So, Lordship, what I intend to say by placing this, the two notifications were issued after the commission decided to hold the re-evaluation and conducted re-evaluation of the waymark by applying the technology available with them in exercise of their duty under the good faith clause, which is vested with the commission. And in exercise of that, commission has found there were some defects in the procedure.
Mr. Chatterjee, don't request. In the meantime, you have made me aware of that. Come to the point.
So, Lordship, the point is they were not vigilant. They were not vigilant to challenge those notifications. They have challenged it once the commission decided to go ahead with the counseling. That's
So at this juncture, you stand with Mr. Mitro. Mr. Mitro has taken that point.
now here, Lordship, I want to second questions which was troubling your Lordship from the first day. I was listening to your Lordship carefully. Whether it is permitted to conduct the tests, and my elder friend Mr. Shamim has pointed out there is no scope of tests. It is test, my lord. Sometime we look at the documents. Kindly come to the comprehensive affidavit, the advertisement points.
Colombo, 8
Lot of things have been submitted on the question of page 49 of their comprehensive. Page 49 of the comprehensive. The West, don't you got it? Yes, sir. The West Bengal Madrasa Service Commission is going to hold the first state level selection test 2010 for recruitment of non-teaching staff, librarian.
You are reading from which portion?
My lord, page 49, I'm starting from the starting of the advertisement, my lord, first paragraph only.
I see.
The West Bengal
Yes, I got it.
Madrasa Service Commission is going to hold the first state level selection test 2010 for direct recruitment of non-teaching staff, viz. Librarian, clerk, and Group D peon library assistant attendant in government aided higher secondary senior madrasa in the West Bengal and in terms of the West Bengal Madrasa Service Commission Act 2008 against the vacancies reported to be prepared for the post of librarian through written examination, academic score, and personality test. Written examination, academic score, and personality test for clerk preliminary screening examination. Written examination, academic score, and personality test, including type test, using computer and computer proficiency, and for the post of Group D staff through preliminary screening examination. My lord, I pause here and I start written examination and personality test. But marks obtained in the preliminary screening 1 examination shall not be added to the marks obtained in final written examination /TESTS. So it is not the test, but advertisement says it is tests. I got it. Final written examination / tests. It is final written examination which may be divided in tests through various sessions.
Yes.
So I therefore want to raise this issue before this court, and I want to frame it in this way, my lord. When the advertisement permitted tests to be conducted in its plurality, then the action of the commission to conduct the tests is justified in order to conduct the written examinations. So I say each test are the integral part of the same written examination. These are not the tests under different written examination. My lord, kindly come to the date of this advertisement rules. Lordship will find it from the top. Published in such and such newspaper, 27th March, Shonibar 2010. 27th March, Shonibar 2010. 27 March 2010. I want to indicate one thing, though it is not my issue, but I will not be justified to discharge my duty as an advocate. But this is my duty to indicate the rule which is being relied on by the Honorable Court, by us, indicated in the first order of the Honorable Single Bench also. Lordship, kindly take the rules once.
রুলটা দাও এইখানে রয়েছে, এইটার মধ্যে রুলসটা রয়েছে।
West Bengal Madrasa Service Commission recruitment and recommendation of persons for appointment of this not this one. No. Just a minute. Oh, watch it. Yes, do দাঁড়াও না ভাই। My lord,
No, Mr. Sami, it's not fair.
this is
Don't distract Mr.
rule
Chatterjee.
is
No.
there. My lord, West Bengal Madrasa Service Commission recruitment, selection, recommendation of the persons for appointment and transfer of the post of teacher and non-teaching staff rule 2010.
Yes, I
My
got it.
lord, kindly come to the date of notification when the rule was notified. 11th November 2010.
Hmm.
But I say that it is the duty on the authority to adhere with the rule, club it with the advertisement, read the advertisement and rule together, and apply it only for the purpose of securing transparency, fairness in the process of recruitment. So, Lordship, in this juncture, I want your Lordship to decide on 3 issues. Whether the commission was justified by notifying 2 notifications. By 1 notification, commission has extended 1. I would not use the word privilege, but I would say that it is a concession to them who were successful in 2010 by protecting their zone, and commission has decided to hold written examination in respect of those candidates restricted to the number which is found after this detection of through evaluation of the OMR, to hold the written examination within those candidates who have been found not qualified in that examination held in 2011, now in 2024. Lordship, we can constitute as session 1, session 2, session 3, and it's just a session 4 of the same written examination. If they want to demonstrate a case of violation of Article 14, they will have to show that their right to equality has been violated, but they cannot show from this fact that they who have qualified in the written test, for the written test, who have become the qualified in the written test, their equality has been hampered. They can only make out a case of extension of the zone of consideration, nothing else. Even today, the pedestal where I am standing in, being an impaneled candidate, even I cannot say that it is my right to get a job. The law is that. So those candidates who are not in the same pedestal, who are not coming within the zone of the candidates who are eligible to participate in the written test, can they be treated at par with the candidates who are not qualified? So, Lordship, there has to be two tests. One is the this reasonable classification test and nexus. Now, I will be coming to that one after another. Now, second question which I will be raising and I will be arguing is, if today, what was the subject matter of the commission to be decided to start the recruitment process again, because it was withheld as per their affidavit. They started and they found there are certain difficulties. Now today, I consider for the time being, commission decides not to allow us in the recruitment process with the finding that there was technological error in re-evaluation. Whether that action of the commission would have been justified in the touchstone of fairness and transparency for which commission is bound to conduct in respect of any of the recruitment process, would have been whether it would have been fair on the part of the commission to deny us today, after detecting the fact there were technical error which erupted because of the latches on the part of the commission. Commission detected. Now, I joined the issue with Mr. Bhattacharya yesterday. He has argued that commission's decision should be read in terms of the order passed by the Honorable High Court several times, single bench, division bench, as well as the order affirmed by the Honorable Apex Court. Mr. Bhattacharya has pointed out that single bench wanted the recruitment process to be completed by giving a time limit. Division bench upheld that. And later on, the matter was moved before the Supreme Court with that paragraph. Then the Honorable Supreme Court also upheld the decision of the single bench as well as the division bench, and your Lordship has also read it. We read the order to many of the times. Now, Lordship, I say that when this was done, the only object which was there in the mind of the honorable judges were that process has to be completed. Process has to be completed. And Lordship, I will say that even the issue when it was raised before the Honorable Court, issue related to the second written test, Lordship, kindly note that commission at that point of the time was proposing for a written test to be conducted separately. It's a fresh with all the candidates, not protecting the candidates who are already.
Mr. Chatterjee, give me a second. Yes, Mr. Chatterjee.
My lord, before I take your lordship to kindly come to page 152 of the uh, comprehensive. And I want to read this application made by the commission in detail. Now let kindly come to 155, a paragraph 2. A writ petition bearing WP number 1722W of 2018 was filed seeking for a direction to publish the result of the written examination of the first state level selection test, which was held on 27 March 2011. In terms of the advertisement published by the appellants as well as the West Bengal Madrasa Service Commission. The petitioners herein had prayed for, inter alia, direction upon the appellants to produce the result for the first level selection test 2010.
You are reading page number
Page number
155.
155. By an order dated 23rd July 2018, passed in WP number 1722W of 2018, titled as Sri Shoumen Malakar versus State of West Bengal and others, the Honorable Single Bench had directed the entire recruitment process of Group D to be completed within 14 days from the date of communication of the said order. The appellants above named had filed an appeal before the Honorable Court seeking inter alia, setting aside of the operation of the order dated 23rd July 2018. The said appeal was taken up for hearing on 4th February 2020, when the Honorable Court was pleased to dispose of the appeal, thereby modifying the aforesaid order of the Honorable Single Bench to the extent that the entire exercise of the recruitment process in Group D was to be completed within 6 months instead of 14 days. Subsequently, due to advent of COVID-19 pandemic, there was a complete lockdown declared by the government, followed by a total disruption in the normal functioning of the courts as well as the normal functioning of the life of every individual, as a consequence of which various applications were filed by the applicants herein, last of which being the CAN number 4431 of 2020, seeking extension of the time to comply with the directions passed by the Honorable Court via its order dated 4th February 2020. This Honorable Court via its order dated 12th September 2013, upon consideration of the aforesaid application, was pleased to extend the order dated 4th February 2020 by 6 months. Copy of the order dated 12th September 2023 is annexed. The appellant states that on 12th September 2023, during the pendency of such application, they had already taken a
Commission
policy
The
decision.
commission had.
Policy decision to conduct fresh written examination for total 1,01,064 candidates, that is 74,618 eligible candidates, which were left out, along with 26,445 candidates who had already appeared in the written examination. Now, at that point of the time, the policy decision of the commission was to club these two sets of candidates. My lord, one is 74,618 eligible candidates whom I belong to, that category, and another category that is 26,445 candidates who had participated in 2011.
It will be a
So
fresh
together.
examination.
Now, so this impression which has been created, we need to clear it, Lordship. The impression is given, it's a fresh examination. The examination which was proposed by the commission as a part of their policy, which was proposed to be conducted among all the candidates who have been found to be qualified in 2010 and who are not found to be qualified in 2010. My lord, therefore, now the decision of the commission, which has to be tested before your lordship today, the decision to conduct a test for this 73,000 separately who did not get a chance to appear in the test, and give a concession to those who have already qualified in the test in 2010, whether a balance has to be brought. And the Honorable Supreme Court in this situation where two confronting set of litigations are coming before the court, has given the roadmap how to address this issue. Very recently, Lordship,
Mr. Chatterjee, prior to going to that,
my lord,
firstly,
maybe Lordship, otherwise also. That is yes.
Mr. Chatterjee, so far I have understood, if I have correctly understood, let me
My lord,
interact.
yes, my
So, I believe your contention is, Mr. Chatterjee, that the action of the commission for holding second written examination for the 74,618 are to be viewed from two angles. One from the angles of the constitutional provision, another from the angles of the orders passed by the coordinate bench, passed by the Honorable Division Bench, passed by the Honorable Supreme Court. Am I correct on that?
My lord, I say that your lordship under Article 226 is required to test this in the constitutional touchstone. And I say that is correct.
I need not.
Yes, my lord. I
need not go. No, no.
I
I need not go through the. According to you, I need not go through the orders. Orders of
No,
the
no, no.
single.
Your lordship is required to. That is the that's the purpose of the constitutional scheme. Yes. I stand with your
So,
lordship.
so let me clear it. What means it would it be your submission that the action of the commission for taking second written examination for the 74,618 are to be tested in the light of the constitutional provision
as well as
the orders passed by this honorable single bench, honorable division bench, honorable.
yes,
Let me note, sir.
yes.
Yes, Mr. Chatterjee.
Well, did I two judgments of the
These two judgments.
first of all,
these two judgments are. These two.
my lord, this is a judgment.
These two judgments are relating to for viewing from the constitutional angle or from
Constitutional
the
service jurisprudence angle and everything. I'll
Please,
2025 SCC online, SC 523
SCC
online, SC 523. 2025 SCC online, SC 523. State of Assam and others versus Arvinda Rava and others. It's a judgment by Honorable Justice Dipankar Dotto and Justice Manmohan.
Mr. Chatterjee, do you want to refer any particular paras?
Well, this judgment possibly will throw some light in a situation like this. But you kindly read the facts of the judgment once. A process of recruitment was set in motion by the office of the Principal Chief Conservator of Forest and head of the Forest Force, Assam, Government of Assam, by issuing an advertisement dated 23rd July 2014 to fill up 104 posts for constables in the Assam Forest Protection Force. Process of selection was conducted in May 2016. The respondents who had applied pursuant to the advertisement participated in the process. They qualified in the physical efficiency test. Thereafter, they were interviewed. It was claimed by the respondents that the select list prepared by the Central Selection Committee, headed by the then PCCF, contained names of the candidates found prima facie fit for the selection and appointment as constable in AFPF, and that such list wherein the names figured had been submitted to the government for approval. Thereafter, in May 2016 itself, there was a change in the political regime of the Assam pursuant to the elections held in Assam Legislative Assembly. On 4th July 2016, the incumbent PCCF submitted a note to the government highlighting serious anomalies that had crept in the selection process. Based on such note of PCCF, but without conducting any inquiry as alleged by the respondents, the government approved cancellation of the select list by order of the Secretary to the Government of Assam. Now, on 17th August 2016, a notice was published from the office of the PCCF in the Delhi newspaper informing all concerned of cancellation of the select list. Lordship, there was cancellation was the decision. Decision was the select list was cancelled. Now, Lordship, I straight away, without wasting your Lordship's precious time, would like to take your Lordship to paragraph number 36 directly. Paragraph number 35 directly. This is very important, Lordship. And your Lordship will find Supreme Court has tried to give some light on this aspects, how this kind of litigations has to be. It cannot be gainsaid.
Let me read, sir.
Para 35.
Yes, sir.
It cannot be gainsaid that the factors of when, which, what, who, and how that are associated with a recruitment selection process is the prerogative of the recruiting authority and the selectors. When, which, what, who, and how that are associated with a recruitment selection process is the prerogative of the recruiting authority and the selectors. However, at the same time, the process has to be conducted consistent with statutory provisions governing the same, if any, as well as the principles of absolute fairness and complete non-arbitrariness. Though it is true that the law does not postulate a fetter on the authority of the employer state, and it is within the domain of the government when to initiate the process of recruitment for the public employment, either according to the recruitment rules or even in absence thereof. It is for the government of the day to decide in which manner it proposes to conduct selection. What would be the various stages the candidates aspiring for appointment have to pass through in order to be placed in the select list? Who would be the selectors, and order to be placed in the select list, who would be the selectors, and how weightage is to be given to each of the testing method. A great deal of credence is lent to a process if it is fairly and transparently conducted in accordance with rules, whatever be its source, without the slightest hint of any basis of favoritism or nepotism. Normally, it is not for the courts to interfere unless the process smacks of malefice. However, the right to be considered for public employment being a fundamental right, it would be safe and prudent to have recruitment rules to govern the process of selection so that the best possible talent is appointed in public service. Obviously, assessing the merit of the candidates aspiring for public employment on the basis of the prescribed standard would not only provide a level playing field for each of them, the excellence of any institution to which the appointment is to be made would depend directly on the proficiency of its members, staff, and made without depend directly professional staff, and that would in turn depend on the quality of the merit of those who offer themselves for selection and ultimately get selected, necessitating the selection to be conducted without any hidden intent or masked malafide. Last but not the least, having regard to the present times when corruption has been held to be work of the life by certain responsible citizens of the country, it would have been desirable if the process of recruitment of 104 constables were conducted after framing of the recruitment rules. That was there. Then paragraph 36. Be that as it may, drawing from our joint experience on the bench, we can say with some degree of conviction and authority that conducting recruitment processes in terms of executive orders and in the absence of the statutorily prescribed standards more often than not invite avoidable litigation producing undesirable results. Let's to us left to us if invite any process of selection was challenged by unsuccessful candidates on the ground of absence of the recruitment rules or on the grounds of absence of written examination or on the allegations of the bias or favoritism or nepotism, which are nebulous, we would certainly not interfere in the absence of any apparent vitiating factors. However, the situation of the present case has taken a completely different turn. It is the successor government which nullified the select list. Hence, the considerations for interference which ordinarily weigh in minds of the court having regard to the peculiar fact situations are not exactly the same here. This aspect of the matter discussed in some more depth hereafter seems to have escaped in a notice of the court. 37, Lordship. As the factual narrative has unfolded, it is not that the High Court was called upon by any unsuccessful candidates to test the bona fide of the earlier government decision not to frame recruitment rules or not to prescribe the written examination or to require the aspiring candidates to only go through an interview on contrary of the facts presented in evidence that the successor government had taken an informed decision not to proceed with the earlier process and to start a new process. At that stage, now a problem has cropped. Now, this is very important, Lordship. I want to emphasize at that stage of decision making, because your Lordship is testing the decision of them. So, your Lordship is required to test the decision making process. Possibly 3 options were available to the government, being allow the process to be taken to its logical conclusion without being unduly bothered by the illegalities and irregularities detected and referred to it by PCCF. 2, from allow the process to be taken its logical conclusion without being to cancel the entire process and start anew. 3, separate the grain from chaff to proceed with the former and complete the process. Here, according to me, the Commission has applied the 3rd test laid down by the Honorable Supreme Court to separate the grain from the chaffs. That is the intent of the Commission's decision, where Commission has decided to remove the defects. Remove the defects.
No, Mr. Chatterjee, kindly come to
Yes.
read from at that stage.
Yes.
Kindly read.
Yes. Separate the grain.
No, sir. Kindly read at that stage of decision.
My lord, which one, my lord? At that stage of decision making, possibly 3 options were available to the government. being allow the process to be taken to its logical conclusion without being unduly bothered by the illegalities, irregularities detected, referred to by the PCCF.
Not done. Not done in this case. Next.
They have decided, I'll
No,
come,
not done.
then
Then
cancel the entire process and start anew.
they thought it, but not done.
Not done. Separate the grain from the chaff and proceed with the former and complete the process.
That has
This is
been
done.
done. That has been done.
Now, Lordship, kindly, no doubt, the government could have set right the process by preferring the third option. In that case, government could have set right the process by preferring the third option, but they have decided to cancel. However, once the government arrived at the decision considering illegalities, irregularities detected by the PCCF, that the process ought to be started afresh and preferred the second option to the first and third option, thereby cancelling the previous process, the High Court ought to have applied the proportionality test to adjudge whether the perfect balance was struck by preferring that option out of the other available options. Sadly, such test has not been applied in that case. My lord,
Give me a second. So, Mr. Chatterjee, before after placing this judgment, I believe it would be your contention. If you say no, please record that. Don't say yes to yes or no to no. I believe it would be your contention that if the proportion if the this judgment or the proposition of law as enunciated in this judgment is applied to the facts and circumstances of the instant case, would it be your submission that the commission has made a perfect balance by opting the right option from the available options? By opting the right options from the available options, and thus the action of the commission ought to have been held that it has passed the test of proportionality.
Yes.
Would it be your contention?
Yes.
Very good. Now proceed.
I have to read some more paragraphs from this.
Yes.
I read it 38.
Have you rightly heard me?
Yes.
That is your
That
contention.
is my contention.
That
Your
the
lordship is
commission has out of the available options, commission has taken out the right options, and therefore it ought to have been held that so far the proportionality test, as enshrined in Article 14 and 19 of the Constitution of India, the commission has passed that.
Yes. Ma'am. And now your lordship is required to test whether the proportionality test has been done in accordance with the necessity of this test. Well, that is something which has to be decided by your lordship. The approach of the single judge, paragraph 38.
Paragraph?
Paragraph 38.
Give me a second, sir. Yes, sir.
The approach of this single judge of the High Court, we are afraid, has evinced an exercise of appellate jurisdiction resting on the sole premise that no allegation of the corrupt practice and unfair means adopted by the candidates had been leveled, and single judge found force in the submission advanced by the learned counsel for the respondents that the selection process cannot be said to be vitiated by malpractice.
Mr. Chatterjee, will you please mind if I request you to please read it once again?
Yes, madam. The approach of the single judge of the High Court, we are afraid, has evinced an exercise of appellate jurisdiction resting on the sole premise that no allegation of corrupt practice or unfair means adopted by the candidates read the respondents herein had been leveled. The single judge found force in the submission advanced by the learned counsel for the respondents that the selection process cannot be said to be vitiated by the malpractice. The single judge also expressed the opinion that mere over-representation or under-representation, though may be suggestive of irregularity or malpractice, that by itself was not sufficient to arrive at a definitive conclusion that malpractice had occurred. Insofar, so the ratio of the candidates called for interview qua different categories of the single judge observed as follows. The regards to non-conformity of the ratio of the candidates called for interview, though it can be said to be an irregularity, but the question is whether such irregularity itself will be sufficient to vitiate the selection process. It may be mentioned that adhering to certain ratio for calling off the candidates for interview is to ensure equitable opportunities to the candidate for assessment, and so that deserving candidates are not unduly deprived of. In the present case, it has been noted that the variation in the ratio is not substantial to be considered unreasonable. Hence, merely because the ratio has not strictly adhered, that cannot be ground for setting aside the recruitment process. Further, though the court has also noted the ratio has not been consistently followed by the selection committee in absence of any allegation of the corrupt practice and fraudulent activity, this court is of the view that mere non-adherence to specific ration ought not to be a ground for interference of the selection process. And thereby the learned single judge there had directed the cancellation to be stopped, because the decision there was the cancelling. Decision there was the second. Out of the three options, the second option they have invoked. In this case, third option. Now, viewed
The
in
learned single judge as passed an order for
directing
go ahead
them
with
to
the recruitment,
recruitment, That is-
cancelling the decision for
cancellation.
cancelling the
Decision of the cancellation, that was in challenge. Viewed in isolation, the claim of the respondents that the opinion expressed may not seem to be flawed. However, the larger public interest the successor government had in mind was not kept in the view by the single judge. Fostering diversity of inclusivity in public service, ensuring that there is representation from almost all the districts, including from the hills and historically backward classes, without, however, compromising merit, should be commitment of all governments of the state in northeastern part of the country. The decision to cancel the select list has the marks edged to proceed towards the commitment of the achieving the greater good. Such a noble initiative was by no means open to the scrutiny by the Judicial Review Court. But kindly note Judicial Review Court. To distinct conclusion in the given set of facts being clearly possible, and the successor government having taken a view which by no means was unreasonable and or implausible, the writ court, instead of substituting its view or imposing its own decision as to what would have been and was the correct option that the government should have preferred in lieu of other options actually preferred, ought to have stayed at the distance. So, Lordship, in this case, this cannot be reviewed by the court. My Lord, it's my humble submission from the Honorable Supreme Court's judgment. It is further useful to remember that the government itself felt that the selection being entirely based on interview, the same admitted an element of arbitrariness, and the assessment of the candidates being based merely on the basis of marks at the interview was reasonable for drawing a presumption of being misused for favoritism and could well be regarded as suffering from the vice of arbitrariness. In such circumstances, it is indeed difficult, if not impossible, for a court to law to substitute its decision for the one taken by the government, reasoning that selection has not been challenged by any unsuccessful candidate. Insofar, Lordship, may I read this paragraph once again? This is important. It is further useful to remember that the government itself felt that the selection being entirely based on the interview, the same admitted an element of arbitrariness, and that the assessment of the candidates being based merely on the basis of the marks at the interview was reasonable for drawing a presumption of being misused for favoritism and could well be regarded as suffering from the vice of arbitrariness. In such circumstances, it is indeed difficult, if not impossible, for a court of law to substitute its decision for one taken by the government, reasoning that the selection has not been challenged by the unsuccessful candidates. Insofar as the candidate referred to the penultimate point of note that PCCF, the single judge has following options. As regard to the allegations, including the non-meritorious candidate, namely, the court is of the option that her name can certainly be struck off and more meritorious candidate can be included in such one of illegality cannot said to have vitiated the entire selection process. The illegal recommendation of such and such is an instance where the authorities can themselves rectify by cancelling the selection, which will not have any bearing on the merit of the other remaining candidates. Now here, Lordship, I want to join issue here with the facts of the case, Lordship. Here in 2010, admittedly, there is one screening that was conducted. And those candidates, their rights to participate in the, because this conduct of written test was to create a pool for the interview. Those selected candidates will participate in the interview. So once their right has been balanced by the decision of the commission, as I said, when commission filed the application, they said that they are going to conduct it for the whole lot of candidates. Now here they have said that no, we are not going to conduct the written test amongst the candidates who have participated in the written test in 2011, and we are going to conduct it only those candidates whose OMRs were not evaluated. We have found it technical defect. We decided to hold it only restricting to them who have been qualified in the re-evaluation.
Maintaining level playing field.
Level playing field. Now, whether the balance has been made between these two groups, not the balance with someone who had been selected in the preliminary test and now did not get a chance to be selected to participate in the written test. Now coming to the court and saying that why I am excluded. not for them. Now, Lordship, I beseech your Lordship to test whether the proportionality test has been applied here by examining the fact whether the balance between our client, my clients, or Mr. Mitro's clients and Mr. Bhattacharya's clients have been maintained or not. That should be the test of proportionality here. Because proportionality means everybody from the same proportions who are qualified for the written test, whether they shall be balanced together. And Lordship, I beseech your Lordship, this is a test, session 1, session 2, session 3. It may be considered to be the session 4 under the written examination. Lordship, there I saw, I have pointed out in the advertisement, it was written examination / tests. Now, Lordship, kindly come to paragraph 39. Viewed in isolation, vis-a-vis the claim of
39
response.
39 we have already gone through.
Yes, my lord. Sorry, 40. It is further useful to remember that the government itself felt the selection being entirely based on interview. It's over. 41 is over. 42, 43. I'm skipping, my lord. Kindly come to paragraph 46. 45. We thus hesitatingly arrive at the conclusion that based on the note of PCCF dated 4 July 2016, the recommendation made by him for cancellation of the select list, the decision of the government to approve the said note and thereby cancel the select list did not stand vitiated to
Mr.
attract.
Chatterjee, where from you're reading?
Page 44, paragraph 44.
44, I see. Place it again, sir.
Yes, ma'am. Whether or not detailed inquiry was needed, despite of the note of PCCF, ought to have been left undisturbed since the successor government reached to a
Mr.
satisfaction.
Chatterjee, if I request you, will you please mind if I request you to read from paragraph 42? Otherwise, it
My
will
lord, my lord.
reduce the
I
link.
should. On an overall study of the note, no person of reasonable prudence would be left in doubt that the process had a coat of discernible tint suggesting impropriety and bias, if not corruption. The applying the test of proportionality, the decision taken by the successor government of cancelling the process initiated by the earlier government cannot be said to be disproportionate and incommensurate with the inequalities, irregularities detected. That interference could have been said to be legitimately warranted. The division bench arrived at its own conclusion that the select list should not have been cancelled without any detailed inquiry having been conducted to find out the veracity of irregularities and illegalities alleged. Whether or not a detailed inquiry was needed, despite the note of the PCCF, ought to have been left undisturbed since the successor government reached a satisfaction of its own that for the various reasons highlighted in the said note, it would be unjust to proceed further. Such satisfaction could not have been tinkered by the division bench on the ground that the detailed inquiry ought to have been conducted. We thus unhesitatingly arrive at the conclusion that based on the note of PCCF dated 4th July 2016 and the recommendation made by him for cancellation of the select list, the decision of the government to approve the said note and thereby cancel the select list did not stand vitiated to attract its invalidation either by application of the doctrine of Wednesbury unreasonableness or proportionality. Before ending our discussion on the relevant issues, we record having perused the decision of Anamika Mishra, Rajesh P.U. Supra and Sachin Kumar. In Anamika Mishra, the court held when no defect was pointed out in regard to the written examination, and the sole objection was confined to exclusion of a group of successful candidates, even in this case that is not. in the written examination from the interview. There was no justification for cancelling the written part of the recruitment examination. On the other hand, the situation could have been appropriately met by setting aside the recruitment and asking for a fresh interview of all eligible candidates on the basis of the written examination and select those who, on the basis of the written and the freshly held interview, became eligible for the selection. Lordship, this judgment was referred. The decision there turns on its fact, with the written examination being followed by an interview. The reasons for cancelling the process were also trivial as compared to very different reasons with which the appellants were faced. The cited decisions is therefore distinguishable. There were no serious grievances or malpractices in Rajesh P.U. Supra. Either, in fact, the court held applying the unilaterally rigid and arbitrary standard to cancel the entirety of the selections despite the firm and positive information that, except 31 of such selected candidates, no infirmity could be found with reference to others, is nothing but the total disregard of relevancies and allowing to be carried away by the irrelevancies, giving a complete go-by to a contextual considerations, throwing to the winds of principles of proportionality. In going further, than what was strictly and reasonably to meet the situation, it was concluded that the competent authority completely misdirected itself in taking such an extreme and unreasonable decision of cancelling an entire selections wholly unwarranted and unnecessary, even on the factual situations found to, and totally in excess of the nature and gravity of what was at stake, thereby virtually rendering such decision to be irrational. Paragraph 35 of the decision of Sachin Kumar has been relied on. In deciding this batch of SLPs, we need not reinvent the wheel. Over the last 5 decades, several decisions of the court have dealt with the fundamental issue of when the process of an examination can stand vitiated. Essentially, the answer to the issue turns upon whether the irregularities in the process have taken place at the systematic level so as to vitiate the sanctity of the process. There are cases which border upon the crossover into the domain of fraud, as a result of which the credibility and legitimacy of the process is denoted. This constitutes one end of spectrum where the authority conducting the examination or convening the selection process come to a conclusion that as a result of supervening event or circumstances, the process has lost its legitimacy, leaving no option but to cancel it in its entirety. Where a decision along those lines is taken, it does not turn upon a fact-finding exercise. A fact-finding exercise into individual acts involving the use of malpractices or unfair means. Where the recourse, individual acts involving the malpractice unfair means, where the recourse to unfair means has taken place on a systematic scale, it may be difficult to segregate the tainted from the untainted participants. In that case, but this is not such a case where tainted and untainted are leveled and they are mixed up. In the process, large-scale irregularities, including those which have the effect of denying equal access to similarly circumstanced candidates, are suggestive of a malice which has eroded the credibility of the process. At the other end of the spectrum are cases where some of the participants in the process who appear at the examination or selection test are guilty of irregularities. In such a case, it may well be possible to segregate persons who are quality of wrongdoing from others who have adhered to the rules, and to exclude the former from the process. In such a case, those who are innocent of wrongdoing should not pay a price for those who are actually found to be involved in the irregularities. My lord, this is also not the case here. May I read it again? Lordship, here, those who are innocent. But this is not a case, there is no allegation from any of the petitioner sides that there has been a malafide, there has been corruption, there has been tainted candidates, someone has taken money to give a job, nothing like that. And Lordship knows the Supreme Court's recent decision, why the Supreme Court had to cancel the entire panel, because they failed to segregate the grains from the shafts. And that's the third test. And now, Lordship, I come to the this paragraph, the important, a fair and reasonable process of selection to the post. From the last line of the last page, which I was going, selection to the post subject to the norm of equality of opportunity under Article 16(1) is a constitutional requirement. A fair and reasonable process is a fundamental requirement of Article 14 as well. Where the recruitment to public employment stands vitiated as a consequence of systematic fraud or irregularities, the entire process becomes illegitimate. On the other hand, where it is possible to segregate persons who have indulged in the malpractices and to penalize them for their wrongdoing, it would be unfair to impose the burden of their wrongdoing on those who are free from the taint. To treat the innocent and the wrongdoers equally by subjecting to former or consequence of the cancellation of the entire process would be contrary to Article 14, because unequals would then be treated equally. The requirement that public body must act in fair and reasonable terms animates the entire process of selection. The decisions of the recruiting body are hence subject to the judicial control, subject to the settled principle of the recruiting authority must have a measure of discretion to take decisions in accordance with law, which are best suited in to preserve the sanctity of the process. Hello, that is something which is very important. Sanctity of the process. The recruiting authority, being the recruiting authority, Madrasa Service Commission was duty bound to preserve, protect the sanctity of the recruitment process. That is the sole responsibility.
So, Mr. Chatterjee, I believe it would be your contention that so far your clients are concerned, or more precisely, those 74,000 and odd candidates are concerned. By no stretch of imagination, it can be said that they are either tainted or they are adopted any malpractice. Please listen.
My lord.
Then answer. I believe it is your further contention that your clients were the victim on account of the wrongdoing by the commission. Maybe it is unintentional, and since such wrong action has been detected by the commission itself, therefore being a model selector, the commission has acted fairly and reasonably to allow you to participate in the second phase of examination by taking appropriate decision in exercise of their right decision to come to a logical conclusion of the recruitment process. I believe that is your content.
Yes, and I will further say that if the commission had not taken this decision,
Just a minute, sir.
Yes, Mr. Chaudhary.
But your lordship has correctly said, it's going to be my contention that commission had the power to decide, and there is no allegation leveled against me. So whatever commission has decided, in order to, I say that to ensure my quality, my chance, my opportunity to be protected, that should be protected, for which I am before this court. But I beseech your lordship to consider one situation. If the commission today had decided not to proceed with their decision to complete the recruitment process today, that was the violation, there would have been the violation of the High Court's order. Number two, there was no option for cancellation left after the High Court order is there. So, my lord, none of these orders have been passed after complete hearing, giving the complete hearing to all the parties. There was no court had the occasion to consider the whole issues together. And I have shown that partly the issue was placed before the court, partly the issues are not placed before the court. So the option of cancellation is no more. Now, lordship, what are we left with? One is to continue the selection process with the irregularity. If the commission today had decided to proceed with it, with those 23,000 almost, then what would have been the effect of that? After detection of the fact that the 73,000, though they were qualified, they were not given a chance to participate. Whether the commission had any option to exercise. And thirdly, lordship, the separating rains from the chaffs, lordship, that is very important. In this case, that was done by using the technology of the OMR. OMR was evaluated. Lordship, there are the cases where it is there. I'll be citing those cases I'll give the paragraphs number. These are well-known cases where it says that if the defects are found, it is the duty of the recruiting agency to remove the defect and carry forward. Lordship, I will finish this judgment first and I will come to those two decisions. Since we find the question 52, Lordship, paragraph
53.
52, 3 onwards. Since we find the question B supra to be question of frequent occurrence engaging the courts of law, it is considered fruitful to take up for an answer now. It has been argued that by dint of mere empanelment, enlistment of the aspirant's name for filling up the public post, no right accrues in favor of such aspirant to move the writ court to redress. We do not consider that an empaneled or selected candidates have absolutely no right to move the writ court. We are conscious of the line of decisions of this court that have noted some of them here, which lay down the law that mere enlistment does not result in accrual of any indefeasible right in favor of such empaneled selected candidates, as well as the law that the employer may, in its wisdom, either decide to cancel or select list or not carry on the process further, resulting in the notified advertised vacancies not being filled up pursuant to the selection process which has been conducted. What it means is that an empaneled selected candidate can claim no right of appointment if cannot claim right of appointment if the state has cogent and german grounds for not making the appointment. However, at the same time, it is also the law that the appointing authority cannot ignore the select panel or decline to make appointment on its whims. Then quoted Shankarshan Das cautions that the state has no lenience to act in arbitrary manner. In R.S. Mittal versus Union of India, coordinate bench held that when a person has been selected by the selection board and there is a vacancy which can be offered to him, keeping in view his merit position then ordinarily there is no justification to ignore him for appointment, and that there has to be a justifiable reason to decline to appoint a person who is on select panel. The position of law finds reiteration in a decision of the recent origin in Dinesh Kumar Kashyap versus Southeast Central Railway, where the majority held the employer must give cogent reason for not appointing selected candidates. Any decision taken, 54 is important, not to appoint, despite there being vacancies and valid select list, obviously, is in the nature of policy decision. It has to be borne in mind that securing public employment is the dream of many who put their heart and soul to prepare for it. Nowadays, aspirants undertake rigorous study sessions as well as training modules to equip themselves, which also comes at a heavy cost. That apart, since every process of recruitment necessarily involves substantial expenses which are borne from the public exchequer, and at the same time, the aspirants for the post who, as per their own estimation, have performed sufficiently well and therefore stand a good chance of being appointed upon figuring the select list, cherish fond hope of a bright and secure future. The law is clear that the policy decision not to carry the process forward must be taken bona fide. There has to be justifiable reason if the process is abandoned midway, and such decision must not suffer from the vice of arbitrariness or the whims of the decision maker. This acts as a check on the employer's power, deciding against not making the appointment from the select list despite availability of the vacancies on the advertised notified public posts. A writ court may, upon reaching the requisite satisfaction, intervene in such manner and make such directions as the facts and circumstances warrant. We therefore do not find it acceptable that the aspirants not having an indivisible or vested right of appointment do not also have the right to question any decision adverse to their interest affecting achievement of the right their goals to secure public employment. Whether to what extent any relief should be granted must depend on the facts of each case. Thereafter, Lordship, the relief here ultimately decided that the appellants are granted liberty to take forward the process of filling up, because it was cancelled, and ultimately held that respondents, if they choose to apply, they said that process is cancelled, let the fresh process be initiated, because the decision was the cancellation. So it was not the court, the Supreme Court did not approve the view of the High Court, where High Court said that you cannot cancel. In this case, they are seeking that High Court's intervention that you cannot issue the notification for the written test.
No, here the Supreme Court has accepted the decision of the government
Government.
for cancelling
Yes.
the.
And Supreme Court has given the parameter. And I say this case should be judged on the basis of these parameters which are set by the Supreme Court in the recent judgment. Now, Lordship, I would like to refer 2-3 things and rely on 2 more judgments, and I will conclude my argument. Now, Lordship, on the question that one point, this was in 2013.
Mr. Chatterjee, before going to any other point, I'd like to put one question to you.
Yes, ma'am.
So for the option regarding separation of the grain from the chaff, that question does not arise here.
No, Lordship, the question was
That question was not
arise, but it is why this option is there. It is basically, Lordship, there is a cloud that what is the
So
problem.
that cloud is not here.
Now they detected that there are certain problems.
According to you, I believe according to you, your contention is that your clients as well as the other 74,000 and odd candidates, including your clients, are not tainted. they have been unnecessarily victimized on account of the uh, alleged unintentional fault of the commission. After passing of the order of the division bench, single bench and division bench, the commission has no option to cancel the recruitment process. So that option goes. The next option is whether to hold the further written examination. That is, according to you, by holding the second phase of written examination for 74,000 and odd candidates who are neither tainted nor otherwise disqualified, have been permitted to appear in the second phase of written examination, where according to you level field has been level playing field has been maintained, and therefore according to you the commission has made a perfect balance, keeping in mind the constitutional provisions, and such actions cannot be called as an unjust or disproportionate, and their action does not make any class among classes.
Yes.
This is, I believe, your
Yes,
contention.
my lord, kindly come to paragraph 37 of the judgment.
And the commission has taken a fair and reasonable decision, which they have absolute discretion, and their discretion cannot be questioned. That cannot be questioned because of any unreasonableness.
My lord, I will try to clear the questions which your lordship has been pleased to ask me. Kindly come to paragraph 37 once, and the third option, that separating grain from the chaff, and to proceed with the former and complete the process.
You are not the chair.
I beseech your
You
lordship.
claim yourself as a grain.
It is a grain, but there was a cloud created in the mind of the commission, because that they found, it was detected by them.
No, I believe so far my
No,
recollection goes
Not so kindly,
that nobody, it is nobody's
Nobody's
case
case is
that
chaff.
you are a chair.
but so lordship, I separate the grain from the chaff and to proceed with the former. It is a
In fact, no
decision.
materials have been placed before this court that you are a chair.
So there it's a proceed with the former. It's a decision of the commission to proceed with the former and complete the process. That's the
So
decision.
has that been taken? Has that action been taken here?
They decided to proceed with the former process, which was withheld. Process of selection.
Separate the grain from the chaff
And
and try to listen, sir. If I am wrong, please correct me.
well,
Separate the grain from the chaff and to proceed with the former and to complete the process. Does it mean that to proceed with the entire examination, select the successful candidates and to proceed with the recruitment process? I believe it is not so.
my lord, in my humble submission, this separating grains from the chaff, it is one phrase. Now, this always doesn't mean it's a tainted and untainted. This is a phrase which is normally used, lordship, where the facts are mixed up. Now, mixed up means, lordship, I say, a process was going on, suddenly process was withheld. The withheld and commission found that the competent, qualified persons were not given a chance for re-evaluation. Their papers were not they required to be re-evaluated. They completed that process and cleared that confusion and decided to proceed with.
So according to you, chaff means unsuccessful.
I want to mean that, because unsuccessful.
I understand.
So that is the purpose of this.
Allow the process to be taken to its logical conclusion without being unduly bothered by the illegally the irregularities not done. To cancel the entire process and start anew, that could not have been done because of the order of the division bench and single bench.
My lord, because of not for order of the division bench and single bench, but lordship for the action of the commission. Commission itself failed to perform it. Commission itself
No,
failed
no,
to-
sir. Cancel the entire process, started anew.
That lordship, yes, that was
Cancel
one.
the, kindly come to pay paragraph 37, sir.
Yes, my lord. Your lordship is referring to the
Page number,
Roman
paragraph number
two.
37, Roman 2, sir.
Roman 2. Cancel
Cancel
the entire
process,
process
started anew.
and started.
That
is
has
what-
been prohibited, the commission has been prohibited.
Commission
Now, separate the grain from the chaff and to proceed with the former and the complete the process. That action has been taken.
that action has been taken, and your lordship is adjudging that action whether that has been correctly taken or not
And that has been done according to you,
by
maintaining
applying the test of proportionality. which
proportionally
lordship
and
will have-
maintaining the balance and without making any class amongst the classes.
That is the my submission.
This,
And
that's
your
very
lordship-
good. Any more?
Lordship,
Any
I
more?
want to refer to one
Be-
judgment.
Before that, kindly
Yes, ma'am.
yes, Mr. Chatterjee.
My lord, Lordship, so far, the point of evaluation and evaluation is concerned, in 2013, 4 SCC 690. This is Rajesh Kumar and others versus State of Bihar and others.
Page number 690.
690.
Do you want to specify any paragraph?
Yes, ma'am. My lord, here the question was, kindly come to paragraph 15. Two 2013 4 SCC 690. My lord, there is, in our view, I'm reading from paragraph 13,
Let me read, sir.
no merit in the contention of Mr. Rao.
Mister, let me read, sir.
Yes,
wait,
ma'am.
wait.
Fine.
I'm not so fast like you.
Yes, my lord.
You agree with it?
Yes, my lord.
Very good. Yes, sir. Please.
Yes. My lord,
It actually it takes time because after making some noting, it comes to
yes, my lord. That always.
as otherwise it will be jumbled up and I cannot recollect who has placed that.
Yes,
Do I take a note, extensive note? Even then I made that system.
my lord, may I read?
Yes, sir.
There is, in our view, no merit in the contention of Mr. Rao. The reasons are not far to seek. It is true that the writ petitioners had not impleaded and the selected candidates as the party respondents to the case. But it is wholly incorrect to say that the relief prayed for by the petitioners could not be granted to them simply because there was no prayer for the same. The writ petitioners, in its evident, on a plain reading of the writ petition, question not only the process of evaluation of the answer scripts by the commission, but specifically averred the model answer key which formed the basis of such evaluation was erroneous. One of the questions that therefore fell to our consideration by the High Court directly was whether
Mr. Chatterjee, wait for a second.
yes.
Yes, Mr. Chatterjee.
But the High Court directly was whether the model answer key was correct. The High Court had aptly referred the question to experts in the field who was already noticed above found the model answer key to be erroneous in regard to as many 45 questions out of total 100 questions contained in A series question papers. Other errors were also found to which have been referred earlier. If the key which was used for evaluating the answer sheets was itself defective, the result prepared on the basis of the same could be no different The division bench of the High Court was therefore perfectly justified in holding that the result of the examination insofar as the same pertained to A series question paper was vitiated. This was bound to affect the result of the entire examination where every candidate, whether or not he was party to the proceeding. It also goes without saying that if the result was vitiated by the application of the wrong key, any appointment made on the basis thereof would also be rendered unsustainable. The High Court was, in that view, entitled to mold the relief prayed for it in the writ petition, issue direction considered necessary not only to maintain the purity of the selection process, but also to ensure that no candidate earned an undeserved advantage over others by application of an erroneous key. The decisions of this court in Bharat uh, Amratlal Kothari versus Dosu Khan Samadhikan Sindhi.
Mr. Chatterjee, where are you from? You are reading?
16, para 16, 697, my lord.
Oh,
And the state of Odisha versus Mamta Mohanty, relied upon by Mr. Rao, are clearly distinguishable. The power of the court to mold the relief according to the demands of the situation was never the subject matter of dispute in this cause. The power is well recognized and available to a writ court to complete justice between the parties. The first limb of the argument advanced by Mr. Rao fails in accordingly rejected. Now, Lordship, kindly come to paragraph 19. The 19. The submissions made by Mr. Rao are not without merit. Given what was the submission? Paragraph 18. Appearing for respondent number 6 to 18, Mr. Agarwal submitted that he had no objection to the order of the High Court being modified so far it replaced a fresh examination by re-evaluation of the answer scripts on the basis of a correct key. The Council for the Staff Selection Commission also submitted on instruction that the answer scripts had been preserved and could be subject to a fresh evaluation. The learned counsel for the parties were further agreeable to the key proposed by Dr. C.N. Sinha, Professor KSP, such and such. Then the submissions made by Mr. Rao are not without merit. Given the nature of the defect of the answer key, the most natural and logical way of correcting the evaluation of the scripts was to correct the key and get the answer scripts re-evaluated on the basis thereof. There was, in the circumstances, no compelling reason for directing the fresh examination to be held by the commission, especially when there was no allegation about the malpractice, fraud, corrupt motives that
So
could possibly
actually-
vitiate.
that has been done by the commission.
Yes, I wanted to show that only. My lord, kindly come to paragraph 21. Here it says that there is considerable merit in submission of Mr. Rao. It goes without saying that the appellants were innocent parties who have not in any manner contributed to the preparation of the erroneous key or the distorted result. There is no mention of any fraud or malpractice against the appellants who have served the state for nearly 7 years now in the circumstances. While inter made position may be relevant for the appellants, now the letter need not be inevitable and inexorable consequence of such a re-evaluation. The re-evaluation process may additionally benefit those who have lost the hope of an appointment on the basis of the wrong key applied for evaluating the answer scripts. Such of those candidates as may be ultimately found to be entitled to issue appointment letters on the basis of the merit shall benefit by such re-evaluation and shall pick up their appointment on the basis of according to their inter se position in the merit list. My lord, I wanted to show that this approach, correct approach, has been adopted by the commission, my lord. My lord, I will conclude. I have other judgments, lordship, which says that unsuccessful candidates cannot, because it's a well-established proposition, my lord. I summarize my argument. my lord.
Just a minute, sir. Before summarizing, probably we will adopt the argument of Mr. Mitra and Mr. Bhattacharya
Yes.
with regard to the exercise done by the commission in holding the second phase of written examination, even after passing of the order of the single bench, division bench, and the Honorable Supreme Court in the dismissing the SLP.
And I will
You are adopting that argument.
adopting, and specifically I'm saying, as Mr. Bhattacharya has pointed out yesterday, that the judgment order passed by the High Court to Supreme Court, each order wanted, the essence of the order is to
For
complete
extension.
the procedure. complete the procedure, complete
the
the
process.
recruitment process, complete the recruitment process. And I say I only supplement that particular proposition by giving the Supreme Court judgment passed by the Honorable Justice Dotto and Justice Monmohan that the test, which test has to be applied by the Honorable Court to decide whether the decision of the Commission was justified. And what is the decision that I have argued on? So I adopt their submissions to that effect that Mr. Bhattacharya particularly submitted that there is no violation of the order, rather Commission wanted to implement the order of the Honorable High Court. Therefore, initially I cleared the grain that this was an
So the
It was a test.
the observations made by the division bench in the MAT, those are basically, as Mr. Dhar argued, is basically an orbiter and was never a ratio decidendi. That is your contention.
And none of the cases, Lordship, has been argued at length. Every facts were not
So
placed.
those observations came for simply for the purpose of disposal of an application for extension of time. The core issue was not that whether the commission would be permitted to take further examination or not. That was not the core issue. That is you are accepting that.
Now, my lord, I summarize. Lordship, I say that this court today, in the 11 writ petitions are before this court, and your lordship is adjudging the conflicting interest of two groups of petitioners. I would say that there are three groups. One, who are unsuccessful completely at the they competed at the preliminary stage. They were knocked out. They could not be succeeded at this stage and could not get a chance to go for the written test. Now, a section of the successful candidates who got chance to sit in the written test in 2010, and another sets which I represent, they got a chance to sit in the written test in 2023. And Lordship, this was done, Lordship, the 2024. Lordship, these are the three sets of petitioners are before your Lordship. Now, I say that the last two groups, that is 2010 written test and 2024 written test.
No,
Lordship,
three sets are one set. They participated in 2010 examination.
Lordship, all of us.
Please listen to
Yes.
us. Listen to me. First set who participated in 2010 examination, but according to them, they could have come under the successful list, but because of your inclusion, the cutoff, because of the raise of cutoff marks, they have been outlisted. I believe this is one group who are
Lordship,
represented by Mr. Mojumdar, Mr. Samim, and Mr. Ahmed.
my lord, I say that
Try to understand what I'm asking. First group is those persons who participated in the written examination of 2011.
not all. There are maximum. That's why I wanted to show your lordship from the petitions that almost all the candidates, except one or two candidates from Mr. Shamil's petition and another petition, I found 2-3 who have succeeded in. Some of them have succeeded in the written test. There are many who have not qualified in the preliminary test also.
Very good.
That is one. So, Lordship, I think that is the
Very good.
the balance has to be drawn for the proportionality test between my clients and Mr. Bhattacharya's clients and Mr. Mitra's client, Lordship, that whether there has been any violation of the level playing field or not. That has to be tested. My lord, I conclude my argument by saying that the commission was required to take a decision to complete the recruitment process in a fair and transparent manner. Commission had to take all the decision keeping the sanctity of the recruitment process in mind. Commission had the prerogative to take a decision regarding who, how, what, and when, as I quoted from the Supreme Court decision, and Commission has taken that decision. Now, commission first, what was the stages of the decision, Lordship? The first, they decided to start the process again. And in order to clear the doubt, they decided that the defect which was found, that due to application of the wrong key applied to the all candidates participated in the preliminary test, the result was not properly done. In respect of those whose result were intact and are there, Lordship has found that these documents are digitized document, must be there with the commission, and everything is there. So, Lordship, and it's a technology which has to be applied. So, error, it's not a human error. So, this can always be detected, and commission has detected that. And once upon detection, commission has found this is the problem, that 73,000 candidates who could have been permitted to participate in the written test, they were out of the process, they were left out. Now, commission were to undertake one exercise, how to bring these sets at par. And commission has issued 2 notifications, and those notifications are, Lordship issued, one is on 5th, one is on 8th or 9th. 8th. These 2 notifications were issued, and these 2 notifications I would be submitting, your Lordship. It's the 2 sides of the same coin. Same coin is that how to bring the equality between these two, balance. Lordship, I referred to the advertisement. I said this advertisement included written examination / TSTS. So I answer to Mr. Samim's argument that it is not the test, not the tests, but test. I say, Mr. Firdoshan, yes, my right friend has submitted, so I am replying to that. Obviously, to his submission only, I will reply. So then Lordship, another aspect, Lordship, I said that advertisement was date of advertisement and the rule, date of notification of this rule are 2 different. Advertisement was in March and rule was in November. But Lordship, I say that this can be clubbed together and read, because there is a rule. Commission is bound by this rule. Commission is bound by the advertisement. So, Justice Supreme Court judgment deals with these 2 situations. In some cases, there may be absence of rules. It is not a case of absence of rules. There is a detailed advertisement as well as a detailed rules, and it permits. Lordship, so I beseech your Lordship that as it is already held by the Supreme Court that it's the anxiety of the youth, unemployed youth, who are looking for the job of the Group D. They're waiting for 15 years, my lord. In that situation, the belligerents came before the court, and not even immediately after the issuance of the notifications, but after a substantial period of time, they came before the court at this stage when the commission was verge of giving the appointment through holding the counseling. We were called for the counseling. Very good. And how far it would be justified. Grateful.
Any other person who will argue on behalf of the petitioners? No. Sir, I request all the members of the bar to give reply purely on the law point. Don't enter into the factual aspect. I will not allow a single factual argument any further. Purely on the point of law.
Only not kindly permit me to address Mr. Bhattacharya's submission in the anvil of his petition, because I did not have the occasion to deal with that.
No, Mr. Majumdar, you have to confine your argument only with regard to
Not
law point.
he did not.
I will not allow you any more.
He did not reply me. He had
Very good.
projected his
You
own
will get
case.
the advantage, no, Mr. Majumdar. Mr. Majumdar's case number is WPA 24588 with WPA 25438 and 21918. Am I correct? So once again, a gentle reminder, please ask your learned advocates on record, go through the cost title of the earlier orders or the last orders so that no discrepancy took place.
The appearance.
With regard to the appearance, numbers, names of the learned advocates, whatever may, and the case numbers. Yes, Mr. Majumdar.
But there is a commission who has advanced argument in support of its action. There is one set of persons who had participated in the 2010 process and wants this action of commission to be supported. That was Mr. Vikas Ranjan Bhattacharya, learned senior. And Mr. Sabyasachi Chatterjee, who is participant of the 2024 process. So he also wants the carriage of proceeding from 2024 onwards through the written test. But so far as Mr. Sabyasachi Chatterjee's clients are concerned, they are trying to board a running bus. They are trying to board a running bus. Process was directed to be completed from a stage, not going back further. Taste and tests has been completely misread in that advertisement. Page 49 of my writ petition, that advertisement, your lordship will be pleased to find, there is a reference to type test and personality test. Please come to page 49 of that advertisement. But we are not reading a statute, section 13 of the, we are not reading section 13 of the General Clauses Act. That singular would include plural.
Page number?
That's the advertisement, page 49 of the comprehensive affidavit in opposition.
Comprehensive. Sorry. Yes.
The West Bengal Madrasa Service Commission is going to hold the first state level selection test 2010
Sir, come to the point, main. Very good, very good.
for direct recruitment of non-teaching staff, namely so and Group D, in government aided so schools. In terms of the Act, against the vacancies reported to the Commission for appointment to the post of non-teaching staff advertised herewith, the panel shall be prepared for the post of librarian through written examination, academic score and personality test, comma. For the clerk, preliminary screening examination, written examination, academic score and personality test, including type test using computer and computer proficiency. And for the post of Group D staff, through preliminary screening examination, written examination and personality test, full stop. And this is Group D. So these are the three mode of assessment. But marks obtained in the preliminary screening examination shall not be added to the marks obtained in the final written examination, stroke tests by the qualified clerk and Group D candidates. That's why the expression tests had been used, because it refers to two categories of employees. One is for Group D, the other is for clerks in Group C.
Very good.
Preliminary examination is one. Written examination is one. Why tests? Because it is personality test and typing test.
Very good. Next.
So, my lord, that the advertisement conceived of more than one written examination or tests to be conducted is
I
probably not
understand, sir.
borne out.
Next.
But next comes the question of not the proportionality in the action of the commission. Not what the commission failed to achieve before the division bench cannot be achieved at the behest of some other persons before your lordship's court.
Yes.
Not today, not what the parties propose to, I mean, purport to invite this honorable court to do is they seek review of the judgment of the honorable division bench, in effect.
Yes. Next.
But your lordship had already taken note of the stand of commission before the honorable division bench. That is pages 148 to 151 of the comprehensive affidavit in opposition. The so-called detected irregularity factum was there before the division bench. You know, one preservation of data in digital form has led to setting aside of or not cancellation of 26,000 candidates' future. Let us not depend on Mr. Sachi Chatterjee's argument that the commission has transparently preserved data. Let us not go into that. Now, to review a decision from the stage of holding a written, after holding of written examination, is neither contemplated in the anvil of the advertisement, nor in the rules, nor can the commission take recourse to such path after the division bench order. More so, nobody before your lordship has taken the responsibility of answering apropos the stand taken by the commission after the November 2024 order. 25th November 2024, an interim order was passed by this honorable court, a coordinate bench, directing to carry on with or restraining further process to be continued. The commission says we want to comply with that without undergoing this, without taking into consideration the next examination of 2024.
Please answer to that point which has been raised by Mr. Dhar regarding ratio decidendi and
Please come to that, Ken. That is probably the emphatic answer to his argument. Please see his own stand. What is a ratio or what is an issue? An issue is crossing of swords. I say something, you deny something. So there is a crossing of swords that gives rise to an issue.
Very good.
The commission has said that I want to conclude this process by inducting a large number of 73,000 candidates or 78,000 candidates in a process.
So that is the core issue.
That is the issue. The court says no, no further test. The commission is bound by that order.
That you have argued, sir.
That order has been defined in section 2, subsection 14 of the Code of Civil Procedure.
Very good. Any other point?
Now, the judgments read upon, I shall just cursorily refer to the judgments. But that 2020 volume 6 SCC 689 had revalidated certain provisions of the Madrasa Act. And that is beside the point involved in this case.
That has got
No
no,
relevance.
that has got no
No
relevance.
relevance. Now, not 3 judgments were cited that a judgment can, for the proposition that judgment cannot be read as a statute, and what is ratio decidendi. Number what is difference of circumstances in this case? Apropos what was projected before the Honorable Division Bench at 3 or 4 stages when they sought for extension of time. What is the difference of circumstances? Now, does it not, when your Lordship's court is a court of equity, and what separates your Lordship's court from any other civil court in the under the sun is exercise of discretion. Today, does it not appear to be suspicious that after holding a written test or examination in 2011, the Commission revisits an examination or personated or a preliminary examination of 2010? What, in terms of the advertisement, 40% is the qualifying marks for the purpose of moving on to the next round. The next round has attained the finality. The next round has attained the finality. The train has left the platform. Now the Commission goes back to the platform and checks for some more luggage. And there are certain persons who want to board the running train.
Very good, sir. Any other point?
That ratio decidendi is an inverse test. That's not 2018 volume 6 SCC 21 paragraph 114. The proposition is,
You want to rely that?
not I'm only distinguishing.
Very good. Yes.
Not an obiter is something when statements are not necessary for making a decision. That is obiter. But the statement was before the Honorable Division Bench that there are certain irregularities in the preliminary examination process.
That is in the can.
That's in the can.
That is in the can.
I'm not,
And averments is there in
There.
the can.
and it's recorded in the Division Bench order twice.
Unable to comprehend.
Yes.
With the wording unable to comprehend.
Paragraph 13 and 17. I need not trouble your Lordships. By this time, your Lordship probably knows that wordings by heart. So I'm not troubling your Lordship.
That's all right.
Now, what is that inverse test of ratio decidendi? If decision remains same, even with removing the opinion, then it is not a ratio. Now, can the Honorable Single Judge be invited to replace the view expressed by the Honorable Division Bench in the teeth of the facts which were already there before the Honorable Division Bench? That statement made by the Commission was already there before the Honorable Division Bench.
No, Mr. Mujumdar, their contention is that basically those cans were for extension of time to publish the result.
Why? Because of these
On
reasons.
the ground that results.
Court says
So,
no.
no, according to the commission or the those who are supporting on the supporting the stand of the commission, they say that it is neither a ratio decidendi nor an, as you said, that the core issue before the commission. The core issue before the commission, core issue before the division bench was for extension of time.
I don't say that please give me 6 months time. I want 6 months time because of XYZ reason.
Yes, yes, of course that.
The court says I have considered this and I answer it in the negative.
So according to you, that cannot be reviewed in this statement. Very good, sir. Any other point?
Then there were judgments cited to the effect that justifying a preliminary screening test, but nobody says that this is unjustified. The advertisement says so, the rules of the commission says that there has to be a conduct of preliminary screening test. This has been done. Results published. Whoever had attained 40% had moved on to the next phase of the selection process, that is written examination or written test. Written test conducted, why result was not being published. So the court said carry on from this phase. or from this stage and complete this within 6 months. Commission says, I can't do this within 1 month's time. Give me another time. On third extension, the final order was probably passed. And Lord, your Lordship has been pleased to record that there was a fine imposed on Commission as well. Then, another judgment was cited for the proposition that preliminary examination is not part of main examination. That the advertisement says so, the rule says so.
Undisputed.
Undisputed. This is a screening process. The process of marking has commenced from written test. Today, please visualize the situation, what catastrophic result this will lead to. Some persons have taken an examination on a given set of questions.
No, sir, I will visualize you, confine your reply. Confine to your reply, sir,
That's it.
on the point.
Please visualize the situation, what result this will lead to. Some candidates have taken and
No, sir, that will invite a factual aspect that I will not consider.
no, this is only on this.
Absolutely, I have argued. I have heard the arguments of the councils.
That's right. So when what Mr. Subhoshaji Chatterjee submits is there is a level playing field by holding two examinations.
No, Mr. Chatterjee was very vocal with regard to the proportionality of the decision by the commission.
That's right, because there is a level playing field prepared by the commission by allowing his clients that 74,000 more candidates. Now, one set of candidates has appeared under a different set of question papers and have been evaluated.
I understand probably. If I've correctly understood your contention, first is that the commission is totally debarred from taking any further examination. The reasons are blah blah blah. One of the reasons that this Reed court cannot sit on the review of the judgment of the division bench. That I understood. So for the proportionality of the decision is concerned, in the anvil of Article 14 of the Constitution of India, what would be your reply?
That's my submission. But one set of examinees have taken an examination in 2011.
Does it create a class among classes? Or is it a reasonable classification?
Cannot be a reasonable classification. That's my submission. I have appeared in the same process, I have taken an examination for the purpose of evaluation in 2011. In 2024, for the same process of selection, persons are getting evaluated through another set of questionnaires.
Of same standard.
Who judges that?
The court will judge.
No, your lordships have not
The court will judge it.
your lordships are not seeing the question paper side by side.
Yes, I have seen. It has been filed. It is with you. It is with you. I can share with it.
It's not
It is
the
of same standard.
It's not the same question paper.
Fieldly, it cannot be. It cannot be. It cannot
Can't be. So not one who is participating in the same process. He cannot have two different sets of preliminary examination. Why 3 sets? Because this was not getting evaluated. This was only a screening process. Evaluation starts from writing the tests.
No, Mr. Mayanda, there are also some difference. Definitely, there must be some difference. Even some digital difference is there. Arithmetical figures difference may be there.
Your lordships have seen today. Nobody gets the
Level playing field must be level playing field must be tested. If my understand goes correctly, whether equilibrium has been made or not, whether equals have been made or not, that is to be not. Whether an equilibrium is made or not.
treating equals as unequals is also violation of Article 14.
How do you say that they are unequals?
One who has not been found to be eligible to sit in an examination, they form a different class altogether.
But if it be the case of the commission, I have not framed my mind. If I am answering against you, questioning against you, if it be that they have been unnecessarily victimized because of the wrong or unintentional wrong committed by the commission.
First of all, not a big cloud is created over the stand taken by the commission.
There is an assumption, sir.
Assumption has to be.
What materials have been placed before this court that they are really tainted?
It's not a question of tainted or untainted. Tainted or untainted is something which is Not, your lordship has seen not what is tainted or untainted in the recent judgment of the Supreme Court. My lord, nobody knows. It's not a question of tainted or untainted. It's a question of commission having, my lord, I have cited
Just come back.
I have cited examples to show that many of the petitioners before your lordship's court today belong to session 1 and session 3 who have been found to be qualified.
Very good. Let us one day for reply. Tomorrow,
Day after.
day after tomorrow. আজকে হচ্ছে
Primary.
We can conclude our exam, Mr. Majumdar is not right.
time is up and I have to take up the motion matters. Is a motion means this is a difficulty. Because on account of on a
Perhaps may not. And may not. Tomorrow 12:30, my senior is. But it can be completed in 45 minutes.
sir, in 45 minutes I can take up the 5 motion matters. Or 10 motion matters. It may be. So not 2 p.m. Tomorrow 2 p.m. I can accommodate.
But only thing today that from 2 p.m. primary will continue. Now we do not know when the division bench, usually division bench starts at 2 p.m. and there is a likelihood that consecutive hearing. And that was started. In fact, today.
With the
Ah,
deepest respect, this court has also
True.
to mean kindly
And-
accommodate, make an arrangement
True.
so that it can be taken up day after tomorrow at 2 p.m.
But I don't stand in the way. If tomorrow lordship
Day after
wants,
tomorrow
I'm
at
not
2
in
p.m.
favor.
sir.
Day after tomorrow.